weeks' time, maybe gives. Just before the vacation, it was your lordship, so I'll pursue it in 2 weeks' time, your lordship. Yeah.
Jurisdiction.
Yes,
Review, review.
there were some questions asked, your lordship. We have to answer it in format, your lordship.
What questions?
Lordship, the delay was not addressed initially. Can it be addressed at the last faggot and invited, and when they have finished the argument?
I think this matter went to the tax court.
No, actually, in this matter, the point I converge for lordship is that my substantial right is going to be affected. The honorable judge,
Oh, there was a subsequent notification, you wanted a review on that.
not subsequent notification. I'm so sorry, my lord.
What is this notification number 577 dated 8 May 2025? Oh, what is this? No.
It's not.
It's regarding the listing of this case in this.
Oh, sorry.
Maybe it has not been decided on merits. The honorable court said we have decided few matters similar to this, and there is a delay. Right. There actually the admission stage were disposed of, but if your lordship looks that order also,
5 years previous
5
was
years.
explained.
and we have explained that.
Restriction, so we discussed that after the passing of order by RDC, Reproduction Commissioner, in the year 2012,
Right.
the restriction
Was filed in
in 2017 or
17.
so
The
that-
lawyer
that
actually
is,
expired.
Summarily, I think. was
Yes, yes.
rejected.
It has not been dealt with on merit. But that order itself is allowed, but eventually it is mentioned dismissed. That is also peculiarity. If your lordship looks at that, seeing that the judgment on the basis of which it has been referred to.
This is on 20th of March. The order you want to review,
Yes,
is dated 20th March.
yes. It was the order is
You want to review.
right, 20th March 2023.
So this was on the ground of delay.
So there are two
He says
grounds
after
limits.
more than 5 years.
Yes,
So we're just sleeping in a slumber
yes.
and suddenly woke up.
No, in fact, I have explained that in paragraph 33 of my REIT application. It has been explained.
What explanation?
So the lawyer who was interested was arguing the matter before the revisional court. That lawyer actually obtained a certified copy, but he expired thereafter. He did not communicate anything. So only after the communication was made that it has been rejected, we approached the lawyer, the office was closed.
But now, sir, it's a fresh mind.
Right,
Forget what we say.
Correct.
Now, suppose if this being the position, a court has decided a particular cause and saying that there is a delay. Whether the explanation is sufficient, the explanation is cogent, is I would say, the subjective satisfaction of a judge.
So absolutely.
If a judge does not find it, maybe another view is possible. One should arrive at the conclusion that it is a sufficient cause. Does it invite a review?
So
It's
why
an
I say-
erroneous decision. It may not be.
Sir,
There are
I'm-
two things left to
Correct.
the judge.
Right.
Either to accept the explanation or not to accept the explanation. If he does not accept the explanation
Right.
and say, no, dismiss. The only forum is you can go higher up
Well,
on the ground of reasonability,
Right.
rationality.
Right.
So this may be termed as an erroneous decision.
Right.
But not an error apparent on the face of the
so
record.
why is after the face of the record? I'll just explain, man. 2 minutes, man.
Is a
So kindly have a look at the order on the basis of
It says that after 5 years,
No,
and the judge has said,
So kindly look at page 38. Page 38, man.
the judge has given his reasons. The
Okay.
reasons may not be appropriate.
So page 38, kindly have a look at
Of
of this rate appeal, man.
yes,
Review application.
yes,
13/9/2012.
38.
13/9/2012.
Yes, yes, correct.
But in this order, kindly look at page 39.
Yeah.
In our considered opinion, I got it.
Rightly dismissed.
Rightly dismissed by the Revisional Commissioner. But we feel that, kindly mark here, but we feel that he should have independently dealt with the claim of the petitioner for settlement under OGLS Act, passed necessary orders. Accordingly, the order and observation in respect to rejection of the petitioner application is set aside. Kindly mark your word. And but claim of the petitioner of settlement and read application is dismissed.
Incongruity, it's an inconsistent, mutually destructive observations. If you say that the appeal was rightly dismissed by the Revenue Divisional Commissioner, then what was the occasion of interfering with that order?
They have set aside the order. But they have set aside. I am not challenging this order.
No, you will not, because you are beneficiary.
No, I am not a beneficiary.
Yeah.
But I filed a writ application with this code of the order was referred to. Since we have dismissed the writ, I think this writ has.
But you wanted to arrive at the destination of challenging an order passed by the Revenue Divisional Commissioner independently in your independent proceeding. Taking advantage of this.
Sir, I had no independent proceedings.
What?
So I was an opposite party in their applications. Kindly visualize one thing. I was the opposite party in their applications, those cases which have been dismissed, but liberty has been given to reconsider. But their cases, I am opposite party. Since the court observed in the said application that my settlement is not correct, therefore I had to file a writ application.
Why? Why? Then you have to file an appeal against this. Or a special petition against it. If you are a party.
Yes. But here I have not noticed. It's an admission stage.
You are a civil lawyer. Ex parte decree has the same binding precedence as of a contested.
So it is binding.
Say so.
So it is binding. But if you also look at that order which is followed.
Whatever. But once you were a party, you suffered this order, maybe an ex parte. You could have gone there for setting aside the ex parte order.
Sir, I am not agreed with this order.
So when you are not agreed, then what remains?
Sir, remains is that observation of the commissioner, RDC, which is against us, that is the reason why I filed an independent writ.
Can it be done? I'm asking you, can an appeal lies? I'm talking in a civil sense.
Yes.
Against a particular observation when
It's a finding.
when you were a successful party in the proceeding.
Sir, I'll show that. Kindly look at the impugned order in the writ application. Kindly look at that.
I'm thinking of AIR 1922 Privy Council and 54 Capital.
So if you also look at the operative portion of the judgment, which was the subject matter of challenge, in view of the findings stated above, impugned order dated 26/12/2009 passed by the collector in Suez is set aside. Settling the matter in Pew is set aside. So my settlement, which is set aside. If he has set aside the same, I have to challenge it.
Where?
Before the High Court panel.
How? This is a High Court's order.
No, sir. It's not High Court. Page 73 in the writ application is the RDC's order.
What the RDC says, the RDC means the first thing was the settlement was done in your favor.
Yes.
They challenged that order of settlement before the RDC.
So X, Y, 3, 4.
Whatever,
Right.
your settlement. And then the RDC has set aside the order.
Right.
No, sorry, RDC dismissed the appeal.
No, rejected their claim. Right.
Means
Yeah.
upholding the settlement in your favor.
No,
RDC.
that is incorrect.
Then what has happened?
So not only dismiss their application, but also set aside my order. That is the peculiarity here.
No. I could not get it. Because the observation, what I find is that the RDC dismissed the appeal.
Dismiss all the appeals that have been filed.
But now whose appeals were filed by somebody else.
Yes.
Challenging an order of settlement in your favor.
Right.
You were arraigned as an opposite party.
Yes, I was contesting that also.
Right. So I'm just asking. Please.
Right.
Then once the RDC dismissed the appeal means the order of settlement in your favor stood upon
But he has set aside it.
Now, please, I am coming, sir.
Right, right.
So at this appellate stage, it is to confirm. It will not confirm, affirm. Let us show.
Right.
Appropriate word is affirm. Affirm.
Correct.
Then they challenge that order before the writ court.
They challenge.
Correct. They challenge. I said they challenge. The writ court set aside the order of the RDC.
RGC.
Means there are two aspects. That the fallout of this is that the order of settlement which was done in your favor,
Right.
that was set aside.
In fact, that was set aside. So my
Now,
report-
once it is set aside,
right.
can you come forward?
Sir, actually, even though it has been set aside,
You were a party in this proceeding.
yes.
Can you come forward?
So my
With an independent
limited
resolution.
prayer is
Challenging this,
no, I'm not challenging it.
you will not.
Right.
You wanted to challenge that order of RDC or what?
RGC.
RDC was in your favor.
No, sir, RGC was against me.
Against. I told you what. Tell me the fact.
I'm telling you, sir. Let me clarify. Well, my great grandfather was a lessee of Nazrul land. He applied for extension.
I have gone through the facts.
Yes, sir.
I have gone through the facts.
Sir.
He applied for extension. It was
Extension allowed.
1914. It was 1914 that particular first
Correct.
lease was there. And then it expires. Then he died. Then two
Wife and daughter.
they were there. Then they also expired.
That's
Now
right.
you are the only. You are a daughter's daughter.
So I
You are
applied.
the only you applied.
Sir,
Now, in the meantime, certain portion of the property has been carved out.
carved out.
And the
50,
settlement was
50.
done in respect of 0.88 or
Correct.
0.088.
0.88. Absolutely. You're still have.
I have read it. That's why I'm saying
Right.
it's so clumsy and confusing. The writ petition. I was unable to figure out.
Oh,
that what is
I'm
the
so
fact.
sorry, Lord. I'm so sorry.
So this is
Now
what
the lease deed has been executed in my favor.
now it has been executed. Then somebody came forward and challenged that.
Why is a challenge? They say on a portion of it they are in presence. Janata Party.
Whatever I have seen, that president
Right, right.
president of the whatever the party, I do not want to name the political party,
Sure.
that's there. They came for challenge that settlement in your favor.
Yes.
Then what happened? The authority before this challenge was made,
Right.
what he did,
May I read that operative portion?
what he did, he set aside.
He set aside my lease.
Okay.
He rejected their appeals.
No. The authority set aside your settlement,
Settlements.
the lease deal. Then that order was challenged by you before the RDC.
So that is the final order of the RDC. That is a challenge for the High Court. There is no other forum.
Any original, that is the RDC is the original authority.
Yes. No, he is the appellate authority, the revision authority.
Then who passed the original order?
So on that the collector.
So collector, what he did?
Collector settled in my favor.
Collector settled.
Yes,
Let me
yes.
understand the clarity.
Yes, yes.
The
Collector settled in my favor.
settled in your favor.
Right.
Their objection
Right.
was not there before the collector.
No.
Then they challenged the order of the collector before RDC.
RDC.
That means the settlement in your favor and granting of lease in your favor. They
But the
challenge
subject matter challenge.
before the RDC.
Right.
RDC dismiss.
No, RDC rejected their applications.
Oh, that means
and set
dismiss the
aside my.
appeal. RDC dismissed the appeal.
Yes.
It's RDC is an appellate authority, you said.
No, the revision authority. the appellate-
Whatever, revisional authority. So he dismissed their revisional application.
Right.
True. That means the order of the collector was affirmed
But he has set aside.
and
But he has ordered the lease is granting of lease.
but what the RDC did.
RDC not only set aside my lease, but rejected their appeals.
Let me understand.
Yes.
The RDC dismissed their revisional application. Claim that you are not entitled
Yes.
and
Set
they
aside
therefore
my
I reject, but also set aside the order of the collector
Correct.
granting settlement
in
or
my
a lease in your favor.
right.
So it was a mixed bag.
Yeah.
Then this order of the RDC was challenged by him in this writ petition, by them in this writ petition.
Right.
Correct? See, so order of the RDC was set aside.
Set aside. Well, High Court.
Toto.
What the High Court said, set aside the order, remit the matter to reconsider their applications.
Correct. So there are two ways to look at it.
Page 73 of
Just-
the brief, if you also look.
Just let me understand. Then, yes, the claim of the petitioners for settlement. Settlement in respect of the same land which is settled in your favor,
88 decimal, right?
in respect of the same land, portion of the land which
Yes,
is settled in your favor,
yes.
they are keep making a rival claim.
No, they are saying that in a portion of it, they are having a office. Part of it, not the entire.
Say
Right.
that, sir, one simple word will give a
Right.
clarity.
Right.
A part of it,
Part.
not the whole of it.
Part.
There, please. Now, so far as the other portion of the RDC is concerned, where your settlement, the order of the collector is set aside,
So to say.
did you also challenge that in the writ petition?
Yes,
When after 5 years?
after 5 years. After 5 years.
Obviously, that why not the court will take the plea of
Delay.
such level?
And delay has been explained. In a recent,
It's again, I see. Delay, definitely, I am conscious of the constitutional decision of the Supreme Court way back in 1969,
right,
where 5 judges bench 3-2.
so I have got this one to the effect that once you
So-
entertain the writ
No,
application,
there are two aspects. If the writ petition is entertained after inviting the objections or a counter affidavits or something, at the final stage, then there are line of judgment which says,
yes,
at that stage, you should not take a plea of
No,
a
delay.
delay and duchess. True. But if it is at the admission stage,
sir,
can
actually,
it not be taken as a point?
so I bow down to your lordship. Previously, in our
Because at the
High Court,
admission
they
stage,
used to admit and place it for hearing. Nowadays, actually, your lordship are issuing notice on admission. That is the difference. But issuing notice of admission is the same.
no. No.
But sir, 2017, now in 2024, the court passes an order. And visualize one thing. And my predicament is this, Parrot. They have set aside the RGC's order, the judgment I read, Parrot. Court has followed it. So I should
You
be.
did not challenge because you were also the aggrieved person when the RDC set aside
Yes,
the
I'm there.
settlement in your favor. What you were doing, why you were just sitting tight over the matter. Even in this matter also, you could have intervened and challenged the other portion of the order by way of a process
We have
cross
blocked it
objection.
in that, in
Those
those.
order 41 rule 22, you can do it. You could have done it.
If your lordship observes one thing, that will be sufficient for me, in fact. Now the order of RDC is set aside. In the judgment, it is mentioned.
I understand. It should be an open one, the
Yes.
whole of it.
Sir, if I am given opportunity also, I should also place my case there.
Sir, I immediately understood what
But only I have filed it because my name has not been mentioned there.
But why you did not do it? I should not, you are the best person to say. When this order came, you could have. You were a party to the proceeding.
So party to the case, but actually no notice was given to me.
Whatever, then what is the remedy? If
But-
the summon is not served and an ex party decree is passed, then you know.
For same order, different persons have filed different writ applications. But my 5 years has been explained that my lawyer expired.
But if the court did not find it as a satisfactory one, does it mean that it is an error apparent on the face of the record? So
But-
your own conscience tell me.
Now let me very clarity on my thought, Millard. Since the court has not decided on merit,
Is it obligatory in a suit which is apparently barred by a limitation?
I absolutely discretion.
Not the court decide the limitation issue
Absolute
first and then
discretion.
will not enter into the merit?
What I make to submit for lordship is, well, substantial justice and delay and latches. And substantial justice is to prevail.
No. Only thing is when a technical justice is pitted against the substantial justice, it is a substantial justice which will have the edge. But it's not a technical justice. It is really a
The
substantive.
delay and latch is also technical. They are also.
Limitation is not a technical.
But I limit your but
Limitation
Here-
is not.
here the order says, the previous order of the High Court, they have set aside the order. Once they have set aside the order,
But the portion, but the problem is the remedial operation, remedial portion. Remedial portion is troubling you when it restricted only to their claim.
here actually, sir, party is, if you also looks at approach, you'll see for the purpose
One
of.
of the rules. In more deep swing. Please read paragraph 4 slowly.
In our considered opinion, the appeal of the petitioners has rightly been dismissed by the Revenue General Commissioner, but we feel, really mark this, he should have independently dealt with the claim of the petitioners for settlement under OGLS Act, passed necessary order accordingly. The order and observation in respect of rejection of the petitioner's application for settlement
Now,
is set aside.
that is what I'm saying. Now I'm putting it. The order has two compartments. One relating to his claim for settlement.
Right.
And the second compartment is challenging the settlement which has already been done in your. Now the RDC, what he did, so far as the claim of the petitioners was concerned, it is rejected. But so far as the settlement in your favor was concerned, the order of the collector was satisfied. So portions of the order.
Correct.
He can only be said to be an aggrieved person in respect of a compartment of the order by which his claim was rejected, because he would be treated as a successful litigant
Right.
when he succeeded in setting aside your settlement. So he can't be an aggrieved person against that portion of the order. And therefore, the writ petition was restricted to that particular portion,
Correct.
which is reflected in the last sentence.
Yes.
Accordingly, the order and the observation in respect of
The petitioner.
rejection of the petitioner's application for
Correct.
settlement
I-
under such and such is set aside. Means
Right.
the entire order was not set aside. It was a portion of the order by which his claim was rejected was set
So
aside.
I exactly bowed down to
Now-
arguments.
That means the second portion of the order of the RDC remained affirmed.
Of her.
Now you are challenging the second portion of
Right.
after the gap of 5 years.
Fine.
Explain.
But I have explained that. I have explained that part.
Which the court does not find. Now tell me
No.
the review.
The court has not dealt with the way actually it is required to be done. But sir, can I have a look at?
No, you did not challenge that order. You were also an aggrieved person against the order of the RDC.
Sir, correct, sir. That is why I am before you, Lord, sir. Or just one second, madam. But just 1 second, madam. The reason is given by the RDC in setting aside the sale is absolutely irrational and illegal. But if
May the review be extended to that?
the review to extend to hear it on merit, my prayer is only confined to let it be heard on merit. But sir, can you have a look at this judgment, sir? I have given that matter.
Yeah.
The Supreme Court judgment. It is State of Jharkhand versus Azlul Haq. Second page, if you are when substantial justice is pitted against technicalities, necessarily the technicalities will not have to kneel down.
I just told you the technicalities pitted against the
The
substance.
last sentence in that
It's the substance which will prevail.
irrespective of length of delay. Because there
No,
also,
I have said in many judgments.
no, your judgment I have got it, Bharat.
Length of delay is immaterial.
Right.
Sufficiency of the cause is the only factor.
Right.
If the court does not found.
There, if you also kindly turn to paragraphs, I have given the judgment. Paragraph 8. The learned judge who initially heard the petitioner pointed out that referred to the appellate was first rejected on 29 July 1860. It did not matter that the petitioner had continued making subsequent representation. The learned judge noticed the explanation. Petitioner could not approach the court as he was admitted to tuberculosis clinic in June 1961. The learned judge, having found that this was not sufficient to explain the delay between July 29, 1960 to June 1961, was disposed of, rejecting the petition on the ground of matches. But in view of the decision of the majority in full bench of Punjab Court, High Court,
Paragraph 8.
para 8.
No.
After admission of a writ petition and hearing an argument, ruled that delay may
Stage
create the
has
right.
not come, sir. This stage has not come. If the counter affidavits are invited to success.
May call the child.
No, let her go. Why you are keeping? Why you are keeping?
Yes, we will.
You consider it. Don't. Yes, they are to.
Yes.
Yes.
Therefore, the matter was pending since the last 10 years, 17 to 2024, or 7-8 years.
But it was at the admission.
Sir, admission notice are issued usually. Actually, if you also consider every application, you also issue notice to be hard on merit. Once the notice has been issued and it is to be hard on merit, at that stage, without going to the merit matter, if you also reject on the ground of delay, but party has no recourse.
We are in the review jurisdiction, sir. I understand everything, but we are in the review jurisdiction. These are maybe a erroneous judgment, but definitely not capable for a reason. Not capable.
Only to the extent of
No.
kindly.
I don't.
Secondly, court has said in view of the disposal, in view of this judgment, previous judgment, can you have a look at that portion also?
No.
That impugned order, can you have a look at that impugned order?
Correctly said. Correctly said.
In all the cases have to be transferred to the revenue commissioner. Here, let the revenue commissioner
Sir.
last. Therefore, these writ applications are disposed of in terms of the order dated 13/9/2012. Last sentence, but therefore, the writ petitions are
No,
disposed.
this is not disposed of. This is taking into account that particular order. That's all. If you know it better. The languages sometimes English is a foreign language. Sometimes the expressions are not so clear, but at least one can find out the intention. The intention is very much clear from the earlier observations that we have been waiting for a period of more than 5 years.
So that is that if you also look at the previous paragraphs,
That is what it says.
First thing is dispose of. If you are to read paragraph 5, so just read paragraph 5.
Yes, he died.
The court has first taken note of the previous judgment in paragraph 5. But that is also not correct because that was not dismissed as such. That was disposed of, setting aside the order to the extent of the petitioners. But the court has taken note as if the batch of your cases were dismissed, therefore this has to be dismissed. And second line, they say, since the petitioner approached this court more than 5 years, but they have not considered the explanation given by the petitioner.
Let me then state the law.
The Your Lordship judgment also clarifies the position. Kindly have a look at the judgment. Yeah, WPJ read up in 539.
Recent judgment, 1 week back. 1 week back.
171 pages judgment.
Section 5 of the Limitation Act
Yes, yes.
states inordinate delay was controlled by High Court. That was overturned.
Here, paragraph 7 Your Lordship mentioned, dealt with the limitation.
6.
But Your Lordship
Six
said
has to be read conjointly. Conjointly.
the 3 years period granted for the civil suit.
Shivamma.
Miss Sibama is the recent judgment. Yes, that judgment.
That 171 pages.
Yes, that is in 2025.
Yes.
Latest course.
Let us-
The last one.
Yes,
All judgments are considered here. And
In
overturned.
2024, Justice Patiwala's judgment was followed by Justice Pankaj Mittal, followed by Justice Patiwala. Now 171 pages judgment of the appeal.
Mailers have referred that judgment in this order.
So this is how it emerges, but the principle, I think the core principles are still maintained.
Or I just approach Your Lordship's consumer to discretion is the greater partner here.
No question of discretion in the religion. It has to come within the bracket.
But
If it is not, nothing.
Lord, why I say it is error according to the face of the record, one sentence only. Court has not dealt to the matter while adjudicating it and only referred to because I have disposed of, dismissed the earlier writ applications against the same order and therefore I'm not going to interfere. That actually is the clinching partner. Delay was not the main ground on which actually.
I will explain that what he meant by dismissal.
But one opportunity, in fact,
I understand, but review.
but he is not it's not a litigation. Deliberately, somebody has done it. But this is not an excuse.
You could have gone somewhere else. That was appropriate for.
But Your Lordship, those who are in Odisha, people cannot afford to go to Supreme Court government.
You are having a power attorney holder. It conveys a very clear message.
In the last resort, Lord,
Nowadays, virtually more easier to reach.
Sir, we appreciate, judgment, sometimes the good case, sometimes the bad case. What can we do? Yes. The instant application
Entered 100% I have received. Given them.
On Monday, your lordship, and finally counted by tomorrow or day after tomorrow, your lordship.
100% I have deposited.
There was already a reason for deposit of the rest.
50%. Subsequently, the month of May, I deposited the rest amount. In the meantime, 100% I have deposited.
By your.
Your lordship, there is a reason, your lordship, we
There
will
is a-
file a counter affidavit, your lordship.
By an order, it is 31/2025.
Make legal also. It's on the last occasion, one state council, place for 2 weeks time.
Your lordship, we have already instructed.
Yes, they have given an instance of one fake certificates.
Yes, your lordship.
How can a one, I do not know how a particular class which was there in the schedule, under the scheduled caste category becomes a criminal category. I do not know. There are many issues. I think you should find your affidavit.
Yes, your lordship. 2 weeks time.
Counter affidavit 2 weeks. Rejoinder 1 week.
Item number 5.
Minute legal.
My lord, in this matter, we have filed our counter affidavit today. I'm serving a copy to my senior.
They are challenging a particular order where we have been extended the impaneled contractors to supply the results.
Yes, ma'am.
Till 30th of June 2025, 26.
26.
Yes, sir. At the time of hearing of the incident matter,
Item number 6.
now this is I'm just telling you that this academy, has this got any statutory recognition? When it means that certain literally person have constituted it. He has downloaded something from the server without the full copy thereof and wanted to rely as a piece of document. I do not know because I find the appointment is to be made by the government. There are certain government interference in this regard. Tell me whether it has got any statutory recognition.
It's a corporate body, and now, my lord, certain instructions.
What is the formation? Because I do not find that the word we said that we have constituted the Sahitya Academy. Who are we is absent. He has not included any full paper. Where is the document?
That my instruction, that it is functioning under the Department of Odia Language, Literature.
Are they coming directly under the pervasive or a direct control of the government?
Those documents I'll file by way of an
He'll have
affidavit.
to
Yes.
disclose. He has disclosed a very, very truncated manner the documents have been
Yes.
enclosed. Something downloaded from the website without any authenticity, without the full documents.
Yes.
My lord,
I'll produce all the documents, my lord.
I felt the full document available in the website.
That is what, not full documents, sir. It says we. Who are we? Tell me, there should be a name. If it is a society, then it must have the society registration certificate. It must have the bylaws. Everything must be there. Nothing. I have read the entire brief yesterday.
Yes, ma'am.
That's why I'm saying.
And there is all pervasive presence of.
Sorry, you say the government nominee, everything I have seen. But what are the
And earlier also, there were many cases. in
bylaw
the-
affidavits?
Full file.
Sir, if wrongly or mistakenly certain matters have been entertained, does not mean that the court cannot raise an issue on the
Yes,
ground
ma'am.
of maintenance.
Yes, ma'am.
You are a lawyer.
Yes, ma'am.
You
I
can
am
know.
open.
Yes, counter
Okay.
by 3 weeks, rejoinder by 1 week, 4 weeks.
Well, item number 7.
You also made it last occasion, state council.
Now, what is this? 2 crores rupees have been spent to construct a particular school. I do not know who sanctioned the money. The writ petition is very cryptic,
Yes, my lord.
very cryptic. He has not said anything that who has sanctioned money, from where the money came. There is already a school which is there.
Yes.
The government has taken a decision, we are not going to shift the school to a new place.
Yes.
He is challenging that particular decision. He says 70 students are already listed have been given by him. Those who will benefited by that, we do not know. Tell me that who has constructed the school? What is that? It's a government money. The decision has been taken. Why you will not make it functional?
But it was not made functional because, my lord, the school
Then
was.
why you have spent 2 crores? If you have. Because the writ petition is silent. It does not say that who has sanctioned the money, from where the money came. The villagers have decided only things.
But
File your counter.
yes. I have received the instruction. I'll
3, 1,
Fine.
4.
Item number 8.
You have to, when you file a writ petition, I am not very strict. Otherwise, if I go by a strict principle of reading, all these petitions deserve dismissal. Not clearly pleading the cause of action. Be careful in future. Yes.
Item 8.
Yes, why you have eaten up the playground of the children
No, my lord,
by making a construction of the municipal.
no, my lord, steps have been taken for identification of a land for a suitable playground in nearby the school, my lords. The instructions I have received, my lord's letter have already been issued to the test.
1 week counter, rejoinder 1 week, 2 weeks.
Item 9.
May I please, my lord? My lord, in this specific,
Just 1 minute, let me recapitulate what I have read.
my lord.
Tell me that whether this invites a CBI.
Yes, my lord. My
What is the
lord,
law?
yes, to assist your lordships, my lord, I have.
Please, I am stuck by my own judgment. Though it has been interfered by a division bench. But I have-
It is,
he has-
yes, my lord, in
Under what circumstances the court will divert the investigation to the CBI?
yes, my lord.
And under what circumstances the CBI should not be done?
I bow down, my lord, pleases to put these questions, my lord. I have prepared this written notes of them and I have relied upon the decisions, my lord. I want to test, my lord. Turning page 13, my lord.
May I submit, my lord? There is, in the meantime, there is some development. And Lord Advocate General will appear to assist your lordship in this matter. May it then maybe taken up after lunch. Maybe taken up after lunch.
After lunch.
My lord, I may be permitted to start, my lord, because
After lunch, he says, then we start after lunch.
the 2 p.m., my lord.
2 p.m. that is.
Pardon, my lord. I mean, that written note be kept into record, my lord. You asked.
2 p.m.
Well, item 10, item number 10.
I was just only praying, Lord, if could kindly extend the stay order.
We have to issue order.
Sorry.
Interim order was passed by the Supreme Court, not for a recovery. We have passed.
True, madam, but I was only praying, madam, let it be until further orders.
That the matter is still.
I've given the latest order.
It is still pending before the.
It's before the registrar. 1410 order.
And
Item
Item number 14, yeah, for the department, I need 1 week time to file this.
what?
Short date, only 1 week.
What?
In item number 13, we have to get instruction from the department, 1 week.
Yes, you have to clear.
Well, item 14,
Till 1 week, I may be protected because recovery notice they have issued now.
The issue. They are asking for them.
Yes.
item 14.
Ensure that nothing happens.
No.
Yes.
Later on.
Yes.
Yes. Yes, all the.
14.
Item number 14 is regarding the cancellation of GST. Similar.
Item 15,
Please. Yes, the petitioner here is a committee which is formed under the directives of the Supreme Court. Essentially, Millards, what was happening in Paradip Port. Previously, Millards, the labor force was unorganized.
We have asked that previously, you have been given that particular certificate, 197. He cannot now take a different view, say that there is no public.
Millards, your lord, there is no a very beautiful principle that has been developed by judgments of Supreme Court in tax laws. Tax laws, res judicata doesn't apply, but rule of consistency applies. And rule of consistency says, Millards, where a fundamental fact is permeating through several years in course of adjudication, that stand cannot be deviated from because that leaves the SSC in a confused state.
Rudimentary form, the doctrine of stare decisions with assistance. Not strictly applies, but on a factual aspect. That's
In this,
since the knowledge has to be law, it's in relation to fact.
so my among the logic is
Distinguish certain facts that by doing this business, you have developed some other
that is
expenses,
that
which
is
not
at all.
charitable
That is
or relatable to charity.
exactly, that's where my second limb of argument comes. My application, Milad, is filed at 19,525, rejection 19,525. If you had any queries, the notification, which is the CBDT notification, which I have annexed, that says if you have any clarification, you please ask the SS. Nothing asked. Where the same day, and it says you have to take approval from the.
Put a 2 tag mark on the file. Give me.
The lordship, similar matter has been rejected by this honorable court, and the matter they went to Supreme.
He knew.
I have to
understand
verify
cases, in those cases, an opportunity was given and consensus decision has been
And
taken. I marked it that on the 19th May, application was filed, 19th May, the order is passed.
I have to verify lordship because in the para two.
No, please come to annexure 3.
In para 2, it has been written they have submitted various documents on.
Please come to paragraph annexure 3.
Annexure 3, it has been
Page
filed on
34, what is the date?
34. What is the date?
What is
At
the
date.
date of filing is 19/5.
19th. What is the date?
2020.
Come to page 36.
Here,
Right
the
side column.
it may be a lordship application date has been mentioned. I have to verify.
No, sir, this is the order. What is the column?
It is
95?
the request number, application, financial year, and date of filing. It may be lordship.
Which one?
Then what is the date of order? What is the date of order? Date. Or time. Normally
Another phrase must be there, lordship. Order date must be there. I have to verify lordship.
Also the PIN number, your lordship will see, PIN number indicates 19/05/2025 at the top of page 36.
But he is trying to make it that these are the date of the application, the date of the order. In the portion of the order, the container, it says in response, certain documents are there. What is the meaning of the word in response? Yes, there must be. So let them come.
Right. But I've only filed one
statement that the authority with the mail.
Because the shelf life of this petition is very less. It's
Item 16.
My lords, in item 16, learned additional Solicitor General Mr. Nataraj is leading us. My lords, may please, my lords, he is on another court. My lords, may please take it up at 2 o'clock.
What do we? Yes, there are many, there are many councils who will be appearing. I think Mr. Nataraj has some suggestions which he came up in this matter.
Yes,
But they are not agreeing.
acceptable to us.
They are not agreeing. They may have their own version.
My lords, at 2 o'clock, learned ASD sir may address my lords.
Here, Mr. Us is here for MCA. This is the council here. Senior council is here.
He is not.
Look at that. He is so calm and composed and sitting on the back. That means that he is not interested or engaged in the matter. How can you know it?
Blood source. On solicitor general is appearing, so let him be there, then if he takes for any instruction, I will let. So he'll be fine.
Now, are you engaged in the matter?
No. Yes.
Then you ought to have responded to it.
No, he has already appeared.
Yes. Tell Mr. Nataraj.
Yes, sir.
Yes. Argument, open field with the open mind. Mr. Nataraj?
Yes, please, I'm here. I'm here.
Argument from an open field with the open mind.
Yes.
Yes. Standing beneath the sky is a very good one. Yes, your junior wanted you to argue at 2.
No, I thought because I was just held up in the other matter. Can be continued now? I have no problem. Now I'm free. Or else it can be taken up at 2 o'clock immediately post lunch. Whatever suits to the honorable.
Yes, but there is already one matter at 2 p.m. which will be taken up first.
Yes.
There is a continuing matter which is fixed at 2 p.m. Which matter?
Item 9.
Item 9 is fixed at 2 p.m. So I do not know, that may not continue for a longer period. Yes. So, whatever, we'll consider it. Come at 2 p.m. may not be exactly at 2 p.m. because there is one matter. It may continue for 5 minutes, 10 minutes or 15 minutes. I don't know.
Anytime, whatever suits to
No. Yes, just tell your junior to keep a watch.
Please, we'll be there.
Item number 9.
May I please?
You go.
Yes.
For rising, my lord, pleases to satisfy about regarding the direction for CBI investigation, my lord.
My lord, before I may be pardoned. Just a minute, Mr. Man. Lord, before my learned friend begins, just now I got the order from the state government, page 22, my lord. The principal prayer, my lord, 3.
The only thing is the transfer of entire investigation to CBI.
We have already done that. The petition has become infructuous. My learned friend is holding the government order.
Transferred. Then
Yes,
what?
Lord, we want that.
But pleasure to ask me why this CBI transfer?
If
Just a minute, Mr.
government
Mahdi.
has decided not to transfer to the CBI, then the question will arise that why the CBI? Then we'll have to satisfy. If the government has taken a decision to transfer the CBI, it is within their domain. what to do and what not to do. We will simply record that they have already transferred the main prayer. They have already redressed. Nothing remains. It becomes infructuous. Nothing more can be done.
Only humble submission.
What? Why you argue in exhaust your energy on that?
My lord, but I am submitting, my lord.
Just a minute.
Yes.
The derogation of the government of Odisha SOP had proceeded with the matter. That's what I want to show. Only one document.
Let me hear me.
Advocate General is facing that they have handed over the investigation to the CBI. Today he got information. He said only that point only I argue. Because my lord, my lord, the candidates applied, the numbers is 1,53,000 and around 144 candidates has been arrested. So this OPRB is proceeding in a manner which is against the SOP passed by the
Sir, are you standing in the way? Because they have said that now we have given it to the CBI, which is your main prayer.
That is my prayer.
That's all. So now the CBI will conduct the inquiry.
Let them produce.
This is what they have produced. So we'll pressing it on record and then saying that it has been already transferred.
Your Lordship may appreciate one important aspect. Your Lordship may kindly turn to page 2. This petition should be dismissed, my lord, with heavy cost. Lordship may kindly turn to page number 2.
Yes.
Your Lordship may look at the opposite parties.
Yes.
CBI is not a party here. That is very important. Lord, he files a petition very casually. The government is very sensitive. The moment the allegation came, we handed over the Golantara PS to the crime branch, which is also a very, very specialized body so far the investigation is concerned. Since during the course of investigation, it was unraveled that the racket is operating interstate and the investigation is to be conducted in Bengal, in Telangana, in Andhra. It's a national racket which is involved in these recruitment scam. But so far his petition is concerned, your Lordship may kindly look at without impeding the CBI as a party, a prayer has been made that direction should be given to the CBI to take up the investigation. Your Lordship knows the 3 conditions. They are to be satisfied. Either your Lordship may direct for a CBI inquiry or under the Delhi Police Establishment Act.
Mr. Advocate General, now so far as
it's a government action.
Technical aspect is concerned, you were not there in the morning. The bench put a question to him that we are asking everything to be transferred to CBI for investigation.
Right.
You'll have to make out a case. There are a lot of judgments of the Supreme Court when the court should direct the investigation to be done by the CBI. All these things were put to him. So the prayer was made by Mr. Tripathi that you will come. So the matter was directed to be So now once the government has decided to transfer it to a CBI, now the matter is, I think we should not go into the technicalities of it. We will simply put an end to the litigations on the basis of this subsequent event which you have already divulged. So we need not have to go into the technical part. Let us be resilient in this regard.
There are 2 aspects your Lordship may kindly record. Number 1, so far a number of arrests have been made. So far the investigation by the crime branch is concerned, not that the body is incompetent to address it.
That is what I say, that these will come because you are aware of the proposition of law that unless there are strong and cogent materials or evidence that the investigating team is not really working, this CBI is not a matter of routine. It has to be done. Supreme Court in innumerable judgment has laid down the principles.
Yes.
So we are not going into that nuances of the principles because of the government has taken a very conscious decision in this regard. So we are simply recording it and dismissing the matter. Nothing more than that. Simply.
I'm grateful.
What is disposal and dismissal? I have dictated a judgment in the morning.
Serial number
Nothing. There's nothing.
These busy bodies at times without any cogent material knock at your lordship's door that it should be handed over to CBI. Your lordship is
Yes.
absolutely, there are 3 leading judgments. What are the conditions that are to be satisfied to hand it over?
I have also invited his attention to my judgment also there.
Absolutely, my lord, I was going to mention, I am holding that judgment also with me.
So
Your
that
lordship.
is what I said, that under what circumstances it can, under what circumstances it cannot.
I am conscious of.
We are concerned with this. The instant public interest
Deeply obliged.
Item number 16.
My lord, one minute. Lord, accordingly, after the decision of the government, the director of CBI has also been requested by the, your lordship may record it, if your lordship pleases. Lord, the next, the same notification, we have already.
We do not want to enter into Mr. Advocate, because this has been done by the government. The government will definitely now CBI has taken over. Let him take over. Let him
Right. Deeply obliged.
16.
Please.
Yes.
For the apparently I filed an affidavit on the last occasion. I had pointed out to the Honorable Court, pointing out the complete selection process which has been made notionally. And by virtue of it, at the last page, we pointed out that 3 candidates would now make it.
What he has said. No, he has put one chart and all, everything has been done.
Yes.
What is this letter written to me? Who has written this letter? The mail? For correction of the order dated 15th October? And mention of the hearing time? Who has written this? Is there a part of the record I just noticed? I don't know means?
Mike has not instructed you.
Who has written? This is what our email has come.
Antariksha Jha.
Who is representing him?
Antariksha Jha. WF 401 2025.
You are Antariksha. No knowledge. A litigant is making an email and you don't have any knowledge. Improbable and impossible. You are still representing him. What kind of a...
I'm in the first case. My learned friends are there also in the group of discussions.
Mr. Natras, now he wanted that he should argue on merit. You have been fair in your submissions. You said that there are certain irregularities which were noticed. Now, this is the only modalities one can adopt.
Yes.
To remedy the things, because the thing which has already been done,
yes,
which cannot be undone now.
Yes.
Now the persons who have already been appointed,
yes,
now they have to be made a party here.
Yes.
They have a right to be heard.
Yes.
So now you have to take a decision because they wanted a contested hearing to come.
Yes.
Because there are 2 ways of deciding it.
Yes.
If we interfere and say that yes, there is a irregularity, they cannot be, then they have to be removed from service.
Correct.
If they have to be removed from service, then they have a right to be heard.
Correct.
That we can't shut our eyes because that will be affecting their rights. So do you have to implead them as a party? What? Mr. Natraj?
Yes, yes. May I point out the two things here? One is, so far as irregularity is concerned, yes, there is an irregularity. We have done a wrong selection by giving reservation horizontally rather than giving it vertically. There's a mistake. Now, however, on that account, if the some of the appointments which have already been made is to be set aside, now they have to be heard. So
yes,
that is the first thing.
Party.
But however,
Petition, we have made them party, but this is a defective appeal filed by the MCL. They have not made them parties.
No, they were not a party in the writ petition.
Yes.
Some of
When
them.
you see the first writ petition, matter 659.
No, they are filing an appeal against which the order passed in the writ petition where they were a party.
Yes.
So why they have not been arraigned as a party here?
That is a defective appeal, man.
Yes.
Did they file?
Why you have not? If the parties to the writ petitions are not made a party in the writ appeal, the writ appeal is not competent.
Yes, we have made them.
Well, the
Where?
first case, my lord, writ appeal number 406 of 25, where I am appearing.
Yes.
Corresponding writ petition is 6592 of 16.
Yes.
In the representative capacity, at least I have met 4 persons as opposite parties in that case. Those 4 persons, at least they are not parties in the appeal. At least these 4 persons should have been made parties in the appeal.
True.
That is the correct proposition of appeal.
Yes. Only no, two.
No.
Union of India.
Union, nobody has been, because private opposition, they are not made parties.
Yes, Mr. Natraj, where is a?
yes, there is. Yes, like, I think they are not understood. There is no direction to remove them at all. The direction is only to union.
No.
Yes, please see the direction.
No, Mr. Natraj.
Yes, please.
If somebody was already arraigned as a party in the writ petition, then an appeal, if it is filed, then all the parties to the writ petition must be there. Either they should be made as a pro forma respondent,
That's
whatever.
right, that's absolutely
That
right.
has to be made. They have to be made a party.
That is from the day one.
They have been made party.
What is this kind of? Who has filed the appeal? Who has filed the appeal?
Yes, sir. Pro forma.
Show me the writ petition. Show me the writ petition.
6592.
406.
406 is the writ appeal.
592.
527. They have been made parties.
In the consolidated for the amendment, the consolidated petition, all these persons are parties. 4, 5, 6, 7.
No, 567. 567.
Yes, 5, 6, 7.
Find out the consolidated writ petition.
And sir, giving my.
Give.
69 computer phase 69 writ petition.
Yes, they are 5, 6, 7.
Yes.
And even you have not completed, sir. What are you talking about? Just see. It was not pointed out. Where is the appeal?
Consolidated cost title, there it was.
Just 1 minute. Very interesting cost title. Let me first find out. Mahanadi Coalfield, then the director, the person, and the general manager. Yes. So 2, 3, 4 have filed the instant appeal. Then making him and a union to the party.
I think their respondents 13, 14, and 15. That's what it was.
5, 6, 7, you'll have to make them a party.
I think their parties at page number this one 13, 14, and 15. That's what it looks.
Where?
No.
Page.
Cost title does not indicate that they have been arraigned as a party.
Writ appeal 407 or 25.
406, sir.
407, that is the first matter, lead matter.
No, sir, 406 we are talking about.
407.
6 we are talking about.
Yes.
406 writ appeal corresponds to
95 6592.
6590.
At least the cost title, the parties must be correct. So what are you doing? Where is the made? Come to page 3.
406.
Only two persons are there. One is a writ petitioner, another is a Union of India as a pro forma respondent. What about 4, 5, 5, 6, 7?
Same party.
How?
First matter. You have to tell.
Or should I give me 2 days time?
This is how man we are.
Only pointed out this.
Sir, you are putting a question. If you put a problem, then what can be done?
Maybe what I point out that they have omitted the signal.
That is the whole problem. And it can be exercised suo moto by the court. There is no difficulty. Order 1 Rule 10(2).
Yes.
The court can strike out or add any party suo moto also. So,
And those, in my case, those private oppositions were represented by learned advocates.
so the difficulty,
Yes, they have.
sir, who can be said, if somebody is made a party, is he not entitled to a notice? Then you are putting a. No, although the stamp reporter has said that the cost title is in order, within bracket, within quotes, in order, but it is. When you have placed this, so this will be a 406. Okay. This is the matter in the next Monday. Not Monday. Watch a third in between. Put it on 6. Put it on 6. Yes. What about 407, sir? No, no, let us go 406. Then it is 387.
387.
Who is in 387? Is the party, whether all of them had been implemented as a party?
No, ma'am.
Can you show me the writ petition, sir?
Private party is the writ petition number 22918. Next
Writ petition number, it has to be 22915.
When he's going writ petition wise.
In the writ petition, you have not templated any particular party?
That I have not included.
You
So-
have not templated.
so-
So that's over.
So we do not find any difficulty in this. They are absolutely correct. Then next one is 394.
I have added.
394 you have added?
Yes, Lord. In the writ petition, I have added 8% of parties of opposite parties, private opposite parties. Lord.
Yes, where is the writ petition? Either.
23063. 23063.
There is a cost item. No, you have not.
No, I have completed subsequently and notice was issued to us.
No, where is the amended copy?
Consolidated cost item?
Yes, Lord. Everything is there.
Where is
Notice
that?
was also issued.
Where is that, sir?
Yeah.
This is a consolidated. Yes. 5, 6 and 7.
7047.
5, 6 and 7. The same order has to be passed here. You please, sir. 5, 6 and 7. What about the next?
400.
400?
Yes, madam. We have other two persons, the respondent who are. See the contribution.
5 and 6, 2 persons.
2 persons.
Aurobindo Sahu and Suvendu Kumar Tudu. Only 2 persons.
Yes.
Have they included everybody here?
No, they have not made a party.
Yes, 2 persons. What are the 2 persons are?
5 and 6.
5 and 6. As party.
Restriction of 5 and 6. Someone actually.
Then 401. Who is representing? Yes. You are representing 40. Is there any other party, sir? Have you implemented any other parties? No. So it is all right. No difficulty. Then what about 402?
It is all right. I have not added any of these.
No. Then 403, sir? 403.
Sir,
Who is representing?
representing an appeal, but I read petition, I was not the advocate. So I am unable to say a lot of story.
No, whether.
No, but
No, you must have a copy of the petition.
No, I don't know the copy for the I was not representing.
No, you have not added. I do not know whether a consolidated copy was served or subsequently, I do not know.
Because I was not there.
When came the staff report?
I make a simple plan.
402.
403.
Give me time to
403 doesn't.
inspect the record and verify everything and will make the party within a week.
What within a week? We do not want. Within 2 days.
All right, I will do it too.
So we wanted to dispose of the matter. We do not want to linger it on.
3 days time you are not going to get.
No, we are giving you a 2 days time that we'll have to do. Sir, I do not find that you have implemented as a party. We do not find. So their appeal cannot be said to be defective, sir.
407 I have made part.
Then 404.
What about 403 or 4?
404 will not, no difference.
No. 407?
I have made parties.
Have you made them a party?
3 persons. Yes, they have also made. 13, 14, 15.
Yes, they have made everybody a party.
Yes.
So there is no difficulty, sir. 407 is correct. So now, you wanted all the matter to be decided on one day or what?
No,
Tell
one
me.
day.
One day.
At one go, Mr. Natraj, your counterpart here has to ensure the service.
Yeah, please, I will.
This matter on 6.
Please.
And they have to file an affidavit. You have to serve it by tomorrow.
Yes.
We do not want to linger on the matter.
That's
We
right.
Dispose of finally.
Yes. My apologies.
Then you can file your written notes of argument, sir, on that day, so that we will dispose of the matter on that day itself.
Please.
Now they wanted everything to be done on merit.
Yes.
You argue on that day. File your written notes of argument on that day. You have already filed?
I have.
You? All of you have filed? You have filed? Your client is watching the proceeding. Have you not filed? Why don't you file? Why have not filed? They have already found you eligible, so no difficulty. Why your client is so?
On 6th.
On 6th, come. Matter to be discussed on 6th, all the matters. Let's take back whose file is this?
Item 17.
May it please your lordships. I'm appearing on VC. Lordships can hear me?
Yes.
Well, as this matter concerns the correctness of the answer key published by OPSC.
Yes, question number 33.
Your lordship pleases.
Yes. At or from. These are the difference.
Yes, my lords. There is a subtle difference between the two questions of 2016.
Yes, I have read it and I have noticed.
Well,
now, what judgment you want to rely?
Well, I am only relying on one judgment of State of Uttar Pradesh versus Rahul Singh.
Yes.
That
What
is
the citation?
2018 volume 7 SCC.
Where is that?
254. Well, as cited in the judgment itself, it is cited. Paragraph 19.
No, I have read every paragraph. I know. Just I wanted, because the earlier judgment of the apex court is also that is a matter concerning the expert. So it's an expert who has to take care of.
The proposition of law is that
but they are referring certain books where they are saying that when this particular the organon that was published, Dr. Henneman was there, staying there.
May I show your lordships one page, Annexure 7, page 73. Annexure 7, page 73.
Yes.
These are objections that we received from other candidates.
Yes.
And if your lordship sees serial number 2 at page 73.
Yes.
The suggested answer is B. And they say first edition was published when Dr. Hahnemann was at suggested answer Leipzig, and there is a reference book named. So there are certain books also which say that the answer is Leipzig, which is the answer supported by the commission. And there are certain other books which have been relied upon by the respondent, which say that the answer is A. Torgau.
Answer is?
A. Torgau.
A.
A. The commission says that the answer is B. Some candidates also say the answer is B. The respondent says the answer is A.
Now, what the expert was appointed?
The expert was appointed.
What is the opinion of the expert?
The opinion of the expert is B, my lords. In fact, the learned single judge had called for the expert opinion in a sealed cover. That is kept on record in the writ petition, my lords.
Okay. Yes.
My lord, my answer is I have given the answer on the basis of 9 books, my lord, and all are published by all are ISBN and BJ. All are ISBN certified, my lord.
Now, question is that if the expert committee, have decided
on any book, my lord.
They are talking about a book, whatever. How far the writ court should interfere? Can a writ court substitute itself into the domain of the expert?
The decision that my learned friend has led, that only suggests it, my lord. The decision that Rahul decision.
I have seen the decision which is quoted there, and the way the learned judge has arrived at the finding.
May I take your lordship to the?
I think to be very, very fair in this regard, as I believe that unless I express my mind, it is not a transparent way of thinking. I find that the learned judge has misunderstood or misconstrued the judgment of the Supreme Court.
May take your lordship to the pertinent point where I do not know whether your lordship would agree or not, but may I be permitted to place it? May I be permitted to place the excerpt of the judgment wherein
Please place it. We are inviting you to argue.
This completes the resume. Accordingly, first one is correct.
had to be wrong by an inferential process of reasoning. My lord.
If that is the proposition of law, then how can he interfere? And
My lord, or
read the judgment.
by process of regulation, it must be clearly demonstrated to be wrong. I can show
Sir,
your lordship that
there are many books. Some book may say this, some book may say this, some book may say this, some book may. Now the question is, these examiners, if they have the body of experts, if the experts have decided to choose one answer, then the judgment is that whether the court should substitute its finding, there may be different opinion.
The question
we should respect the different opinion.
The question of substitution comes only when, in the first instance, they have
Sir, if
they have
all the
submitted
books
to
have,
be correct.
if all the books have uniformly said something, and there is no book which says different, then in that event one can reasonably infer which is against the judgment. But still one can reasonably infer that they should be. And I think the experts will also agree on it. Here the experts have also referred the book. They have decided on a particular book and says that this is the answer. Then can we defy the decision of the expert?
Now, the experts on the earlier occasion on this case, before the publication of the
question was different. Was different. The question was earlier question was
I'm not
when
that question, ma'am.
The Oregon was published at means which place? This question was where Dr. Hanneman was when the Oregon was published means at a different. Published, a book may be published at say a distant place of the country, but the author of the book may be somewhere else.
That is what I am
The question is where the author was when it was published. So author may be at a different place.
Exactly.
This is what they say that the answer is B.
My lord, on the earlier occasion, the answer was A by the same
Because it was published at, say, for an example, you have authored a book. Sir, for example, I am giving you. You have authored a book. The book is released at Delhi. The question comes that where the book was released, where the book authored by you was released, then the answer would be Delhi. The second question comes, where the author was when the book was released. You may be in Qatar. It is released at Delhi. So the answer would be different. You can't say the answer will be the same.
Let me make it clear, your lordship is comparing both the questions of 2017
I've seen both the questions.
2007. I am not going to compare the other question. Let us decide.
That is what the single judge has done.
Not only that, my lord, he has also relied on the books that I have relied. All the books.
How far his authority is to substitute his own view over the views of the expert.
My experts have not relied on a single book. I have relied on 9 books and all these are genuine books.
At page 73, it is there.
Which book, my lord?
They have reference.
The reference has been made by a student. The reference has been made by a student.
Yes, author is Samuel Hanneman.
I am submitting the books, Samuel Hanneman itself. Well, I am giving the first copy which is not available in India except in Calcutta, outside Calcutta Museum. That is the only book available because the first edition is now out of print. The torn condition of the book that suggests it, my lord. This is the book, my lord, original first edition. This clearly gives the details. This is the first book. And all other books are not Indian, my lord. Whatever books I have got, those are all ISBN certified.
Show us the law. You are reading. Let us understand the
Well,
proposition of law.
The law, it must be clearly demonstrated to be wrong.
Correct.
That is to say, it must be such as no reasonable body of man well versed in the particular subject would regard it as correct.
True. That means one, if the sun rises at the east, if some book says west, then in that event, one can say with certainty that nobody can say that it rises at west. It rises at east.
Now, what the law
If there
requires,
is there is a dissenting opinion, then that event what to do?
what the law requires, that it should not include an inferential process. That means, my lord, we should not.
This is the inferential process.
This is
You are
not an
referring
inferential
to
process, my lord.
those
This is a data. This is not an inferential process. Inferential process is whether in a case of cough, whether they would apply one medicine or the other medicine. That is inference. That depends on the wisdom. A data doesn't depend on the wisdom. Data is written there clear in black and white that it was published at Todgaon. His residence period was there from 1805 to 1811. It was in Todgaon. It was published there from he had written 3 books while remaining in Todgaon, and it was published from there. In the year 1811, he shifted, 1811 April, he shifted to the other place, Leipzig. No book anywhere suggests that he got it printed in Leipzig. He got it printed there. Your Lordship, if permits, I can show you, Your Lordship, the books.
You just show me the law.
Law is there, I told that no inferential process should be required. No, there is no inferential process involved in giving a data, man.
Give me that then.
No.
Give me. And give me that UP, Uttar Pradesh judgment.
Uttar Pradesh judgment is this Kanpur University website submit that the Your Lordship had, His Lordship had relied, my lord. 2018, 7 SCC 254.
Read that as well.
The law is asserted that the onus is on the candidates to not only demonstrate that the key answer is incorrect, but also that it is glaring mistake. Reasoning is required to show that the key answer is applying this principle to the construct case to find out that the key answer is incorrect, can have 2 correct answers. This is glaring and apparent and require no inferential process of reasoning to show the key answer to be wrong. I am relying on 2018 7 SCC 254, madam. Madam, I have prepared a written note of submission. May I?
Give it.
May I place the books, my lord? That would be satisfying your lordship, my lord. Probably without showing the books, I cannot justify with the case.
Your conscience must be clear before this page. We give you every opportunity. Clear your conscience. Then leave it to us.
Do I restrict myself to one question or both the questions?
You have already included many books.
My lord.
Which one you want to just take?
All the books, my lord.
All
the books.
Which portion you want?
My lord, that I'm.
Just go on giving us the page. All the books which we have. It's okay. It's okay. So there's the title of the book. Yes, sir. Which portion you want? First, tell me from. You have not paginated actually. Yes, tell me, sir. Yes, sir. Sir, first book you are referring, please tell us. This is the and Hall, the textbook of medical physiology, towards South Asia edition. You are referring first. Which portion you wanted to refer?
And I'm going to theory at page 23 question 100.
Can you tell a printed page of first?
Textbook of medical physiology. That's a
This is
It also, and you question the fact of what to do against.
You have included the page which talks about only the function of the saliva. What for? We are not concerned with how the saliva works. What are the characteristics of the saliva?
No, saliva
So why you have included this paper?
My lord, saliva, quantity of saliva, my lord.
We are not concerned with the quantity of saliva,
The
sir.
question is relating to quantity of saliva.
No, we are concerned with only question number 33.
33.
Which was decided.
No, this is the, I therefore requested your lordship to go into both the questions or one question.
What the question? Only one question because the learned judge has already decided.
The learned judge has decided on only one question.
So show us only
But
one.
I have relied on two questions.
Sorry,
Therefore,
you have not challenged the order.
Therefore, mother, I am going.
You have not challenged the order, sir.
I have not challenged the order.
So
I can.
So you can't. You have to restrict on 33 only.
Yes.
Show us the 33.
Then, mother, I am going to 33.
Show us.
96 be good. Page 64. Mother, the page 61.
There is no pagination, sir. That is the 61. Yes.
The
Printed one.
My doubt is from it. The 61 of the page 61 of the book. Your lordship, man.
Yes, yes.
I have given the book.
No, this is what is.
The book is there.
No. First edition.
My first edition.
Is 61 the same thing? No, it is the first edition. Comparison.
published in 1810 AD. It was published during Hanuman's stay at Dadgao in 1810.
Where you might get it, sir?
Pardon, madam?
Page 61.
Page 61.
Which column? There are 4 columns which you are reading.
I have just written it, not for the Xerox.
Give me the book.
Xerox I am showing you. This is common method. Year of publication. The first edition was published in 1810. Hanuman was at Tolgao. He was 55 years. Column 1. This is book. Same book. May I hand over the book, madam? Column 1.
Yes. Yes. Yes, I got it.
Column 1, madam.
Yes, I have seen. Even more than Tolgao.
Madam.
Then?
And then, madam, the second book, this is comprehensive study of organum. The 37 last para. Published in 1810 AD, it contained 259 aphorisms. It was published during Hanuman's stay at Talgao in 1810 AD.
Which page?
Page 37, last 4 lines. May I know the original book? Last 4 lines. Original book is there, madam.
Yes.
Last 4 lines, madam.
Yes.
Please hand over the book to you.
Latin.
37, last 4 lines. During Hanuman's stay at Tagau in 1810 AD, it was published, it was printed by the famous publisher Arnold of Dresden. A grateful patient financed the publication. In just 9 years, all the copies were sold.
This is the book written by some Dr. G. Nagendra Babu MD.
Madam. The
Not by Hanuman. Anyhow, then
Hanuman's book I will be giving. Hanuman's book may not be available, madam. Original book, this is the only print that is available of part.
That does not say, it simply says where it is.
Madam.
Then the next book.
Next book is Life and Letters of Dr.
Correct.
Samuel Hanuman.
This is by Thomas
Lindsay Thetford.
This is by Thomas Lindsay, and publisher is B. Jain Publishers.
Madam, all the books are from B. Jain, madam. In India, in homeopathy, all the books are published by B. Jain. Madam, this is book, original book. Page 81. During the years from, you also got it, madam, but page 81, middle 4 lines.
Yes.
During the years from 1805 to 1811, the time of his stay in Talgao, he published several articles in the Dix Engiger. They may all be found in Dr. Duggan's valuable transition of the lesser writings. Then the last but one para. It was during his residence at Targao that Hahnemann gave to the world his great book, Organon der Rationalen Heilkunde, or Organon of Rational Healing. It was published in Dresden by Arnold in 1810. I take your lordship to Samuel Hahnemann, his life and work, volume 1. The chapter 9, starting paragraph.
So, Joan, I have read.
Hahnemann's period of stress and wandering is over. Generally speaking, this restless man's busy life now enters a more settled period. He had only managed to endure a few months in 1804, certainly not 2 years, in Dessau, his wife's birthplace. As from the early part of 1805, there are letters in which the address is Torgau. Here he remained until 1811 for 7 whole years, acquiring in this place his own home and garden. Information pressed at our disposal from a house chronicle in Torgau tells us. Thereafter, the second para indicates when he moved to Leipzig. Leipzig he left
I understand.
1811. This also says that it was published in Torgau. The next book is a treatise on organon of medicine, chronic diseases and homeopathic philosophy. The
publication you say edition was published when Hahnemann's residence was at Torgau. That is what you wanted to refer.
The next book, man.
Anything?
What
is this book?
This is a treatise on organon of medicine.
That you have referred, the page 22 you are referring.
In this page 22, man.
Yes, I have read. The title and the publication. The publication, this edition was published when Hahnemann's residence was at Torgau. Understood. Then next.
I wanted my, in case your lordship would refer to the original book that you have showed.
Sir, I am faster than you in reading. Don't worry. Come, sit and away. Next one.
Then this secret rational art of living. Then this original book. That
yes. Which page you are referring? There.
Giving the original. Now, the first edition. This is one of the rarest books, my lord. First edition. It was published in 1810 while Hahnemann was at Torgau.
Which one?
Last line, page Roman 32. Roman 32.
Roman 30.
Well,
you have done 33.
And another column is also there now.
Yes. And
see column.
Yes. Next.
No, left me. This is also the column organon of medicine, first edition. This same book at another page that I had not entered in this writing, but this is there. The first column. The same book, first column, my lord.
The 108.
Yes. Then, my lord.
Then. The secret life.
The history and evolution of organon of medicine.
not the secret life.
Secret life, my lord.
I have already read the history and evolution. Page 108, you want to refer, I have gone through it. Tell us, the secret of life.
Page 24, my lord. Page 24 and 25 of this book.
Yes.
So Hanuman remained in Hamburg till 1802. He was persecuted and driven from town to town, from Mullen to Edinburgh, to Macon, to Wittenberg, to Dessau, to finally stealing in Torgau in 1805. While living in Torgau, Hanuman gave up practice but devoted himself to research and writings. In 1803, Coffee and its Effects. In 1805, while in Torgau, he wrote 3 very important books: Asclepius in the Balance, Medicine of Experience, Prelude to the Organum, and Fragmenta de Vibribus Medicamentum Cultivis. Fragmenta is the first collection ever made of experimentation of medicine upon the healthy body and contains the record of symptoms produced in this manner upon Hahnemann and his fellow authors. On his book rests Hahnemann's claim of being the father of modern experimental pharmacology. In the year 1806, Hahnemann translated the material.
I got at page 25.
25.
Portion.
25 during
In the paragraph in the year 1806, you have said that he is there. He has written. And next.
In the next part, there are 2, my lord, during 1805 to 1811.
Not necessary. We are concerned with Oregon. Then. Anything more?
My lord. There is Robin Murphy book. 317, my lord. Yes. Madam, this is me. Page 317, second paragraph. The organon of healing of the art is the fruit of Hahnemann's tireless labor during his stay at Torgau. It has been called the work of Torgau, a regular catechism of homeopathy revised and adopted. The first edition was published at Dresden in 1810. The second, third, fourth, and fifth editions appeared respectively in 1819, 1824, 1829, and 1833. The latter, the fifth.
Yes.
The first line itself suggests that it was in Torgau.
Yes. Then
Samuel Hahnemann's his life and work by Richard Hill. Page 80, my lord. Page 80. Essays and writings of Hahnemann of the Torgau period, 1805 to 1811. Essays and writings, chemical and pharmaceuticals. So the period during which that denotes, my lord. And at page 81, at page 81, second, 1810, of personal medicine, Dresden by Arnold, 220 pp. Second edition, 1819, Organon of the Art of Healing. This part, therefore, it suggests that in 1810 at Torgau.
Then I understand.
Then the book, The Life and Letters of Dr. Samuel Hahnemann. This is foreign edition. In 74.
Preceding paragraph of page 17. preceding paragraph of page 73 at the bottom.
Madam.
That's all.
Do I hand over the original book, madam?
It is there, sir. I just say page 73.
Madam, that is the
Last but one paragraph.
Xerox page, that is
Yes, I have already done it.
Then the next book is a journal, that is Birthplace of Homeopathy, Hahnemann's House in Palgao, then and now. The certification number also I have given above, the ISSR 1982-6206-8 up to volume 27. This is the reference. Hahnemann's journey to Palgao. Lordship, what it matters?
Yes, yes, that is the abstract.
Not an abstract matter. This is a journal, publication of the journal.
Yes.
If his biographers made the count right, Samuel Hahnemann moved at least 25 times in the course of his 88 years life. In the beginning, he roamed over half of Europe in pursuit of his studies, which was not exceptional at that time. In 1735, he left Meissen, the city of his birth, for Leipzig, where he took university training. After that, he went to Vienna, then to Darmstadt, then to Sibiu, and finally to Leiden, where he was awarded his doctorate in medicine. In 1790, he spent further time in Leipzig studying chemistry. In 1781, now coming to
Next. There is no next.
then coming to page,
Last one.
page 79, my lord.
I have already read.
In Palgao, Hahnemann continued with his limited doings, in all likelihood,
Yes.
solely on himself. Therefore, all the things point at the only thing, my lord. Palgao is the place where he got it. And the experts have relied only on the only thing that the student has given the reference. The experts have never applied the argument till this examination. They had the
There is a report submitted by the experts during the hearing of the investigation.
the expert has not referred to any book.
Any other? Let's see. Anything more?
No, yeah, on the aspect of the question, these are my submissions. And regarding the
Give me the, you just show me the judgments, which the single bench has relied, you are relying the same judgment.
I am relying the same judgment, but
No other addition.
if your lordship allows me, tomorrow I will be giving a written note of judgments. Judgments
Already given a written notes of argument.
only a written note of judgment.
It's not necessary. You are relying the same judgments.
I am relying only on the one judgment because I never expected such strong resistance. Therefore,
It's not a resistance, it's the understanding of the law.
therefore I will be clearing the understanding.
No different. You are relying only one judgment of the
Yes, my lord. Just for the proposition that if there is a conflict between books and the expert opinion, then the expert opinion has to be favored.
Let us see. Then
Great.
that's all. Hearing concluded. Put it for judgment to be delivered. Call the next.
May I have liberty to submit the judgment?
No, return. Don't keep it. Don't keep it. We have the photocopy there. Yes.
Do I have the liberty to submit the judgments?
You are relying on the same judgment which you have relied before the single bench. He has referred. No difficulty. We will consider all the judgments to have been cited by you. Don't worry. Yes.
Item 18.
The appellant is challenging the judgment dated 14/5/2025 passed by the learned single judge under Annexure 20 euros. Lordship, in the interim judgment, the learned single judge has quashed the order of punishment imposed by the appellant.
Compulsory retirement.
Your Lordship.
Disproportionate to the allegation.
Your Lordship, that is one of
She has all along said that unless the entire action or the entire documents is ratified, She will not be able to take a charge.
Your Lordship, the
You have said that insubordination.
disobedience to the orders of the authority, and Your Lordship,
How can it be? She has to take a charge after all the documents which is handed over, which she will take charge. The authentication has to come.
Lordship, the documents which she had sought for. Lordship, I'm just placing those, I'm just reading those documents, Your Lordship, and annexure 2, Your Lordship, may kindly see.
Are you ready for the final hearing? We will be disposing of the matter at the admission stage. If you are ready, we can continue with the hearing. I have already read. That's why I am asking you.
Your Lordship, those I'm ready, Your Lordship, and one other
Then you
aspect, Your
can
Lordship,
argue because I have also read it. That's why I am asking these questions.
Lordship, may grant me 1 week time, Your Lordship.
Because we will not keep it pending. On that day, we'll dispose of. The point I have got, let us get an answer from you.
Your Lordship, there is another aspect, Your Lordship. In this case, the punishment order, against the punishment order, there is an remedy of appeal provided in the statute, Your Lordship.
No difficulty.
And the delinquent
Is
without-
it an absolute bar in entertaining the writ petition?
Your Lordship, when there is a remedy provided in the
I am asking you, is there an absolute bar in entertaining the writ petition because of the alternative remedy?
Your Lordship, there are certain exceptions under which the without
If
availing
the court has already taken and decided on merit, then as an appellate court, what to do? Should we go on that aspect?
Your Lordship, since the reasoning given by the learned single judge that principles of natural justice were not complied.
Right.
Your Lordship, that is
Second
incorrect,
show
Your
cause
Lordship.
notice was not given.
Second show cause notice, that is not a mandatory requirement, Your Lordship, as per the 42nd amendment. If the first show cause notice has been served, and which was
What
served in
about the
this
judgment of the Supreme Court?
Your Lordship, in 1991 Supreme Court, Your Lordship, also that 42nd amendment was given legal sanctity, that there is no requirement for serving the second show cause. And if
Are you ready? That's why I'm asking. If you argue, no difficulty. Tell us clearly.
Lordship, let me
When?
1 week time, Your Lordship.
When? Tell me when.
Lordship, on 3rd November.
You should come ready
I am ready.
with all the judgments.
Your Lordship, on 3rd November.
Third number, keep it.
Right.
Come ready. Under the same heading.
Yes. Item 19.
Here, the copy of the rate agreement was.
So,
Your Lordship, I have served.
in the meantime,
Item 19.
yes.
That is yours. Here this heat appeal is directed against the orders of single judge. Where is not there is a dispute between the 2 gram panchayat adjacent to each other, 2 gram panchayat adjacent to regard to having a daily heart, that is daily market. Here
What is the sanctity? If the authority, what is the sanctity?
Here the Act provides if there is a dispute between 2 distinct gram panchayats on the rule Act 146 it has to be referred to the Samiti.
What is the effect of the heart to be organized?
This has to be organized by the Gram Panchayat.
Yes.
That is there because there is a provision on the rules of section 61, so also 146, how the hearts are to be conducted in each Gram Panchayat. If there is a dispute between 2 Gram Panchayats for having hearts, then it shall be referred to the Panchayat Samiti and the Samiti will decide the dispute. Here what has happened?
What has happened? He has simply referred the matter to the district magistrate to take a decision.
No, collector took a decision against me, my lord. That has been upheld by this honorable court.
My lord, there is a serious infirmity, technical infirmity in the writ petition. 2 writ petitions were disposed of by a common order. Now, one set of petitioners in the particular writ petition have come up in the writ appeal, and without arraying the other 2 petitioners, because they are also affected by this writ appeal, my lord. Other 2 petitioners are not been arrayed as a party. So, hit by the doctrine of non-joinder of necessary party. Because, my lord, Lordship, common order.
Maybe two independent.
Yeah, and they are
two independent.
Disposed of. One is favor, one is.
Maybe.
But the order which should be passed in this writ petition may affect the other part.
No, what are these are the rival claims.
Rival claims.
And he has not chosen to file an appeal against the other.
No. Here,
Was he
one writ petition he has filed?
Was he arraigned as a party in the other writ petition?
No. Here, what has happened? Collector passed the order. I challenge that order. The other Gram Panchayat came with a writ application for implementation of the order of the collector.
Yes.
Right. So I am asking you whether you were arraigned as a party in that proceeding.
No, not. But I have made the other Gram Panchayat as a party. Opinion number 6, respondent number 6. I have made them a party. Not that I have not made them party.
So order of implementation was allowed?
No, Honorable Court, Honorable Signature Director, because the collector has direction to carry on the heart in respect of that Gram Panchayat, he said that no separate order is required to be passed. But so far as our claim is concerned, he has upheld the order of the collector. Because on each
suppose if the appellate court set aside the order, means what? Then the order of the collector
has to go, and now it has to be relegated.
So impliedly, the order to implement also goes. Obviously, without making them a party or without hearing them.
Respondent number 6 not.
What?
He is there before Lordship. Respondent number 6 is there already.
If two independent proceedings are decided by a common order, can a single appeal against one?
I am not agreed by the order they pass in the other writ application.
No. What?
Because the Honorable Single Judge did not pass any order so far as implementation is concerned.
What has happened to that writ petition?
Both have been disposed of in the same writ application. You also can look at the order.
So, what is the effect?
Effect is that
1 Gram Panchayat.
Yeah, no, that 2 Gram Panchayat. Here dispute between 2 Gram Panchayats. We belong to one Panchayat, and we were conducting a hut on each Saturday. The other Gram Panchayat, which is adjacent to this under the same block, they were also having hut. So if there is a dispute, it has to be resolved by the Panchayat Samiti, not by the collector. They came up in a writ application.
I am on a proposition of law whether the single appeal is competent when two independent proceedings are disposed of by a common judgment.
Yes, yes. Why I say I am not at all agreed by
me. I know the Privy Council judgment against you. Show me the law. If it is wrong, no difficulty, sir.
Then I will come up here because if I am not agreed by because 2 independent writs were filed. The one in my case, the order is against me. So far, the other writ application, this honorable court said that no order need be passed.
Where the court says no order needs be passed?
Look at the order.
Please show us. Show us, sir. Because I am thinking of 2 conflicting order to operate simultaneously at the same time.
No.
Show us.
Yes, if your logic, I will come page 40 minutes.
40.
Paragraph 10.
Correct.
Conclusion. With the above discussion, the final conclusion of the court is that there is no wrong or error committed by the learned collector of District Master Denkanal in taking such a decision followed by the order dated 31st May 2023.
So rejecting your claim was upheld.
Yes.
Yes. Then
at the same time, this court is of the view that the Sarpanch of Gaharmunda Gram Panchayat is allowed to submit a proposal and recording the submission of Mr. Das, learned counsel with the claim that a representation is pending orders. This court is of the view that the same should be considered in the light of the order dated 31st May 2023. There after the representation is to consider.
No difficulty. So what it emerged? That your representation having rejected by the collector, that order is affirmed.
Not my representation, their representation having been allowed, that has been confirmed. Same effect loss. If the order of the collector is against me.
Affirmed.
Yes.
And their claim appears to have been allowed.
But their claim he has directed the collector to consider the representation notes. There is no positive order against me saying that no, I should also not depart from having that. That is why one writ application was a writ appeal. People also see that. This court is of the view that same should be considered in the light of the order dated and the collector conversed as being treated as a proposal for a decision accordingly. So he will now consider.
So according to you, this the representation is pending. Representation is pending.
Yeah.
And that's why the court says to consider the proposal of the Sarpanch of Ghagra Munda GP in case any such representation has been received in the light of an order dated 31st May 2023.
Yes.
So
no, that is our representation. Ghagra Munda is our Gram Panchayat. We had made a representation. Our representation was pending. In that meantime, the collector's order has been affirmed. And when it is affirmed,
no, to consider the proposal of the Sarpanch, you are.
Yeah, Ghagra Munda.
Then how you are aggrieved?
No, Lord. Once the collector has given a dictum that I cannot hold the heart on Saturday in my Gram Panchayat.
So he has said that you consider the representation.
Exactly, Lord. What I'm saying.
So what more?
Yes, your lordships, the Honorable Single Judge has upheld the order of the collector that I cannot hold a heart on Saturday in my Gram Panchayat.
Now they say that now you consider that order is staring at your face.
No, how what he can consider, because his order, which was under challenge, has been affirmed. Now he cannot reverse the order for lordships confirming his earlier order. So the direction that was pending since 2022.
Now what is the effect of this portion of the order, paragraph 12, page 41?
Yeah.
It is made clear.
Yes.
That the order of the learned collector, whatever, as per annexure 1, shall be immediately implemented, notwithstanding the pendency of the decision on any such proposal with the representation. That means his writ petition to implement the order was also allowed.
Well, effectively, it stands to be.
Now you have not challenged this order in that writ petition. So now, if we consider your case, then will it not be a conflicting order? Because your writ petition is to quash the order of the collector.
No.
If the order of the collector goes, suppose, in your case, then the question of implementation does not arise.
That event was, of course.
So he will be penalized for not being heard, not being any order being or challenged, having not challenged that portion of the order which is passed in his writ petition.
No, of course, he will be given an opportunity here because he is a party.
Is it not there will be a stoppel, it will be a res judicata.
In that event, because call it next week, I will file a fresh writ appeal, like filing both can be taken up. Otherwise, why I say not, they are continuing with their hat. They have, it's previous hat. There is no dispute.
Sir, I am on a pure question of law. I am not on the merit.
On the technicalities, exactly, because
there is a vital one.
Yeah. No, why are you saying that? Because
the Supreme Court has also subsequently accepted this proposition.
But because they are party, I was trying to convince a lot.
Sir, if there are two independent proceedings, appeal against one not maintainable. Not maintainable.
I'll file a fresh appeal challenging that order.
It's up to you.
Yes, no, also call it next week. So not saying the meantime.
Adjourn for a week.
Item number 20.
Now then item 20, my lord, I'm appearing virtually, my lord, on behalf of the writ petitioner, Vedanta, my lord. Now, my lord, in this matter, the issue involved primarily is the validity of the amended Rule 45, my lord, in the mineral concession rules of 2016. Though, my lord, an IA has been moved, my lord, we had, my lord, there is an interim order granted by your lordships on 29th March 23, which has been continued, my lord, and are furnishing an undertaking to pay the differential amount, my lord. Now, my lord, my respectful suggestion is, my lord, that the matter needs to be heard finally. And, my lord, if your lordship could put it down on a day convenient to your lordships, my lord, after a few weeks, my lord, we'll come down and physically and, my lord, argue this matter, my lord, finally. That's my respectful submission today, my lord, because only 5 minutes are left, my lord. This IA, my lord, business need not detain your lordships, because according to me, my lord, if the matter can be finally heard and disposed of, that will give a quietus to the entire litigation, my lord.
No, the IAPF will respond.
Who is for the other side?
Well, IAPF will respond by one. No, that is the
Where
Orissa
else to the
Mining
other side,
Corporation.
man?
Lord, Orissa Mining Corporation has filed an IA. Lord, because Lord, the stay order has been continuing, Lord, in one writ petition or the other. But there have been various writ petitions from the year 2020. The interim order has been continuing. Amount payable today by them, Lord, towards the differential amount is not in the range of 4,000 crores. For which, my lords, except that Lord bare undertaking, there is no other security at all. Our respectful submission is, my lord, that the IA may be heard. My lord may kindly start the hearing of the IA. The main matter can be heard because not this is an unending process. Not from the year 2000 has been going on, and the areas are piling up. And Lord, the irony of it is that Lord, they are Lord, from their own mines, they are Lord, producing the ore at 4,000 rupees approximately per metric ton. And Lord, from abroad, they are buying at 7,000. From OMC, Lord, by virtue of the interim orders, they are getting at 1,000 per metric ton. That's how Lord, the areas are piled up to 4,000 crores today by virtue of interim orders being availed by them. So, Lord, in my respectful submission,
What is the interim order?
Lord, if your lordship
Of the
see,
interim order?
just look at, my lord, the order dated 29th March 2023, my lord.
Yes.
29th March 23. If your lordship will see, my lord, first the order on the writ petition in para 3, it records the contention that it challenges the validity of the provision of Rule 45, alleging the same is ultra vires section 13. Then, my lord, on the IA, my lord, for page that is 4417, a separate order is passed, my lord. If your lordship permit me, my lord, I'll read it, my lord. So and so counsel appearing for the petitioner contended earlier the petitioner had approached this court so and so, which was disposed of with the order.
It was an interim order was that you will continue to lift the agreed quantity of the bauxite for a remaining period of the financial year 2022-23.
Correct, my lord.
Subject to the payment of rupees 1,000 per metric ton, which would
That's
be
right.
exclusive, which will be exclusive of the royalty, DMF, NMET, GST, payment and sampling analysis charges.
Correct. No issue, my lord. The order
Which
stands
will be
complied
charged
with and the
extra. You'll have to pay those
Correct.
amounts as upon the petitioner furnishing an undertaking.
Yes.
For the differential amount with
Yes.
floor price arrived by the OMC rules.
Correct. So, my lord, this is the very issue. So, my lord, the fact that the order stands complied with and it's been continued by your lordships, my lord,
So
I can
you
show
are
the
paying
other
at the
orders
rate
passed
of 1,000 per metric ton in addition
exclusive of
to
royalty.
the other
Yes,
royalty
yes.
and DMF, everything.
Absolutely, absolutely. But there's no issue there, my lord. So, therefore, my lord,
According
I'm
to
saying.
you, Mr. Mehta, according to you, what should be the rate?
But
So what is happening?
Rate,
Let me
varies. Rate varies. From quarter to quarter, the auction is done. The floor price is fixed. And this is not from 23. This kind of interim orders have been gone from the year 2000. I'll pass on a short list of dates. For today, my lord may only kindly have a look at that list of dates. That will give my lord a history of this case. My friend Mr. Mudli is there. He'll pass on the copy of the list of dates to your lordships.
Lord, can I just point out, my lord, it will mean arguing the entire matter. Can I show your lordships, my lord? Because then,
It's
my lord,
not
I'll
that.
have to
I
explain to
only
your
want
lordships, my
that
lord.
they must make some payment. 4,000 crores is
Lord,
out due today.
Lord, I'm saying the order has been continuing, my lord. I'm only saying have it after 2 or 3 weeks. I will come, my my lord, and argue the matter physically at the entire, my lord. The lordship may then settle the entire controversy, give a quietus to it.
But with great respect, Lord, let them pay, Lord, 50% of the amount due.
My lord,
Lord,
with great respect, by many.
let me place the list of dates, thereafter my Lord may decide. Kindly see how the list of dates, how the interim orders were passed, Lord, from the beginning. They have been availing interim orders, then withdrawing the writ petitions, Lord, then filing fresh writ petitions, again the interim orders being passed. Lord,
No, I'm sorry.
From the year
That's
2000.
not correct.
No, let me place the list of dates. So that will be, I am not saying anything off the record. Kindly see the list of dates.
Your lordship may look at the interim orders, my lord. Your lordship may look at the interim orders which have been passed, my lord, after hearing OMC. It's not as if, my lord, these are orders
all the
passed ex
interim orders
parte.
are referred.
These are orders passed.
Referred to all the interim orders.
These are orders passed after hearing, my lord.
Whether the affidavits are complete in this matter, I find that the counter and the rejoinder has also come.
Yes, my lord. The writ petition pleadings are complete insofar as OMC and State of Orissa. They have filed their counter affidavits, my lord.
State has filed the counter. What?
State has.
What the state has to do in this matter?
State has issued a certain direction to the OMC for compliance.
We are implementing that. As a result, this demand has been issued.
Union is
Who is representing the state?
My lord, I am.
Yes. Why this matter is pending for a pretty long time? Why you have not filed your counter?
Counter we have filed. Sorry.
You have filed.
Yes.
So everybody has filed it.
Union of India.
Except, my lord, central government has not filed.
Is a central legislation or the state legislation?
We have not filed the counter, my lord. Yes.
The central, my lord, the rule is
the central
subordinate
legislation or the state legislation.
But the rule
it's
is
a
under
subordinate
challenge.
legislation.
Central.
Mr. Mehta, 1 second. It's
So
a
far as central legislation is concerned, they have challenged the virus thereof.
That's right, my lord. I challenge the virus rule
So
45
virus has to be understood. So far as the claim is concerned, based on that.
Yes,
so,
my lord.
I think union does not require any affidavits to be filed. It's on a pure question of law that has to be decided.
That's correct, my lord. Your lordship absolutely right.
So far as the claim is concerned, so far as a per metric ton or something of that kind is concerned, it is a state subject.
My lord.
It's the state. The claim.
Orissa Mining Corporation conducts the auctions, and Orissa Mining Corporation only, my lord, gives the this bauxite ore.
Can we?
It's based on rule 45 only.
On 10 to start the day with.
My lord, if it's not inconvenient, could I make a request? Otherwise, I'll come on 10th, my lord.
Please come on 10th. You come on 10th. Everybody wants to come in person. 10, come on 10th.
My lord, 10th, my lord, I don't have difficulty, my lords. My lord, in that case, my lord, would my lord kindly, my lord, consider keeping on 26th of November, my lord, as the final date.
Why we wanted to dispose of on 10th?
My lord, can I request for Can I request for a different date, my lord, if it's not inconvenient? Otherwise, I'll leave it to your lordships, my lord. If it's difficult for your lordships to accommodate, then I will not press it, my lord. Otherwise, I had a request, my lord.
Let it be on 10th, my lord. If my lord 10th is given to my lord, I will not make myself. I'll be able to make it, my lord.
Please make it convenient on 10th, because that would be the first day.
My lord.
Start. And we'll finish on the same day.
My lord.
Come with the written notes of argument. There is no difficulty. We'll finish off.
We'll do that, my lord.
Yes, sir. I don't think that is required to be filed by the counter by the Union of India.
Oh, sir, we have already said that so far as your role is very negligible.
Yes. They have challenged the virus.
Argue whether these provisions are in tune with the constitutional ethos or any other statutory provision. These are the rules.
Exactly. Yes.
Whether it is in conformity with the Parent Act.
My lord.
Yes.
That's the only thing.
Yes.
These are the two grounds.
Yes, sir.
My lord, please.
On the ground of reasonability, let us see. I do not know. I have not opened the brief.
No, my lord, sir. We are saying ultra is the main parent statute, my lord, apart from other grounds.
Yes, not
It is in conflict with the Parent Act.
Yes, my lord. The enabling provision, my lord, doesn't give them the power to frame a rule like the present one, my lord. That will be one of the principal
Let us
grounds
see.
apart from
Let
other
us-
grounds, my lord.
So,
come on, 10th.
Lord, we are disputing that. Of course, Lord, we'll.
That's a matter of Mr. Mehta. That's a matter of legal interpretation.
That's a matter of argument.
We will
Let's
see.
say, my lord.
The matter is listed.
for a period of 3 years, for non-completion of a single work. Thereafter, pursuant to order of this honorable court, petitioner allowed to carry out the work, and the work was successfully completed on 10/2024. The chief engineer who blacklisted, he now recommended the government for revocation, but no revocation has been considered.
Why?
So I file a IA for that.
What is this, madam? This instruction exercise, which I find particularly here, is something which is beyond my imagination.
The undisputed facts are that the.
So you have been served with a copy of the application. He has raised and flagged an issue that the government must take a conscious decision. Will you not approach the authority and say that if you want to take a conscious decision, take. If you decide not to take a conscious decision, let the instruction come. We'll decide what to do.
Already communicated this IA to the department, my lords, 1 week time.
This is not expected. If the same recommending body who recommended for blacklisting has said that you please consider to lift it because of his conduct, will you not review it?
My lords, in this matter, my lords, in a different petition, the petitioner had given an undertaking that he'll complete the works in 4 months, but however, that work is not completed.
But whatever the authority who is in the helm of the affair, he has not raised that issue. He has rather, according to him, recommended that you reconsider blacklisting. He has done the work successfully.
The completion certificate I annexed.
Oh, I understand. I understand. That is what I'm saying.
I'll take instructions, my lords. My lords, only with respect to 1 week, my lords, I'll take instructions.
7th. Yes.
Item number 22.
Covered by this WMT.
Oh, this is already covered.
Yes.
By my own judgment.
Yes.
The dry metric ton.
It should be done on the WMT basis. And this.
Yes.
No. Yes. All the connected matters.
All.
Item 23.
My lords, I am appearing on behalf of the respondent through the hybrid mode.
This is what you are following. Yes.
23. I am appearing on behalf of the respondent.
I am for the applicant, my lord. If the issue is, my lord, whether the tribunal has power to direct for compensatory interest, my lord. In fact, your lordship has already decided in the leading case, my lord.
It's an identical issue, Lordship, the periodical.
6%.
Yes.
But, my lords, I'm appearing on behalf of the respondent. It's the same issue my lords have already decided by the order in respect of OTAPL 29 of 2025. Lordship, that's the order dated 9th of May to 2025. By virtue of that order, my lords have approved the findings of the Honorable Tribunal. With one modification, my lords have granted 6% of interest instead of 12%, what was granted and approved by the Honorable Tribunal.
Interest has been reduced.
We have, that's.
It has been reduced, my lords, from 12% to 6%, I must fairly admit.
Yes. 6%.
My lords, only 6%, but otherwise, my lords have acknowledged the entitlement to the interest that has been.
Yes.
All are same.
So, all are same.
All 14 appeals are on the same side.
Yes, call the next.
Item number 24.
Obligement.
Condonation has not been done.
Well, the other day, Lordship had Lordship's order by Lordship, wherein the Lordship had dealt with all the judgments of the Lordship and there was the delay of 495 days.
But now a further improvement, sir.
630.
In a recent judgment, recently the Apex Court has also delivered a judgment. Shivamma, 171 pages. Considering all the judgments on all the judgments concerning the Section 5 condonation. I think just a week before.
Yeah, no, in September. It's September.
I'm sorry.
No, we have been circulated today. Recently.
This is 12th September 25. That is 2025 INSC 1104. 2025 INSC 1104. SHI BAMMA Shivamma versus Karnataka Housing Board.
What to do, sir?
No,
how much days delay?
650 days. 650 days.
Yes. Have you read?
Just go through that judgment. Lordship may grant me reading time for 1 week so that I can.
Now there has been a.
Yes.
May I use a paradigm shift?
It is now in that judgment it is clearly laid down that if you cannot file within this specified period. Delay occurred in specified period are also to be explained. It is not that from the last date till filing, but within that period also, specified period. Why you could not file within that specified period? That also you have to explain. That also constitutes
a week's time so that I can go through that judgment and right from that.
Sufficient reason also is constituted.
We have only one usual reason we are assigning in all the cases.
That cannot
still from the Lordship.
The postmaster also is considered. And,
There is one judgment which I was a party there, a division bench, on the role of the government and the functioning of the government department also, where it has been held that we are writing a letter that does not absolve them from the responsibilities of taking and steps.
Which department is there a delay of 4, 5 months, 6 months like this?
661 days.
Nearly 2 years. 365. 365.
It's also 6,000 and all. Things. Principal will have. In order.
Yes, when?
Next week, when he did.
Third?
Third.
Maybe on sixth.
Extending the holiday. No, we have get a request for accommodating and third, my lord, because we have received that is up to a lordship, but because of this give month. No, we are working. We are working full-fledged. Yes.
Item 25.
6th.
Madam.
So, obliged. Here also there is a delay of 824 days.
The case of regulation 38 years.
I understood. That's why I am saying these judgments.
815 days delay. For morning. Third, the same day.
Sixth.
6th.
Come on, 6th. And also go through this judgment.
Yes, yes.
Item 26.
Okay, you also filed when you were this.
Yes.
Here, worship, a particular rule sheet under challenge.
Which rule?
The particular rules consider that is Annex 10.
Yes. Copy of the resolution.
The notification that is. Rules that is Orissa Panchayat Executive Official Service Method of Recruitment and Conditions of Service Rules.
Yes.
2021.
Yes.
Which takes up the entire right of the Gram Panchayat lordship. It amounts to interview the autonomy of the Gram Panchayat. That's Gram Panchayat. That is contained with Article 40 and 243G. Lordship may post under as per the Gram Panchayat lordship section 122 speaks of lordship appointment of executive officer lordship. But by virtue of the statute rules lordship, the state government has enacted law giving entire authority to the government officer, that is collector. He will appoint and without knowledge of the Gram Panchayat. So, lordship kindly see a particular provision of the 122 of the Gram Panchayat Act.
Who is for the other side? So you will be arguing?
Second.
Because the Varis is under challenge. Yes.
In fact, almost all agreements are completed in last year.
Yes.
Let's can come to 122
Of
Odisha Gram Panchayat Act 1964.
120?
Lordship.
Yes. Yes.
Yeah, 122 says lordship, every Gram Sassan there shall be Panchayat executive officer to be appointed by the collector who shall maintain the records of the proceedings of the meetings of the Gram Panchayat.
Remain in custody of such records of the documents, cash, valuables, securities belonging to or vested in under the direction, management and control of the Gram Sassan.
Lordship. And lordship exercise such powers and discharge such duties, other duties, and perform such other functions as prescribed. Then the Panchayat executive officer appointed under subsection 1 shall act as within the local area of such gram, or gram as may be assigned to them by the collector. Then 3 lordship, subject to the provisions of the subsection 1, the Panchayat executive officer shall function under the control and supervision of the Gram Panchayat. Lordship, here, lordship, now lordship, after this amendment came into force lordship in the year 2009, and after such a long period, lordship, can you see that provision of the under 22, here lordship, by way of a deployment, without appointing permanent post on the Gram Panchayat.
What?
By way of deployment, lordship.
No, what you are referring, which provision?
Lordship, 122 lordship.
Section I have read.
Section 122.
That's then?
Then I'm just reading this section lordship.
Correct.
This section lordship, this earlier this post was secretary of the Gram Panchayat.
Okay,
By of amendment, they have inserted this provision as executive officer.
correct.
And while Lordship employed this language executive officer, they did not give appointment to the executive officer. What they did, Lordship, the VLW and VLWs, Village Agriculture Workers Lordship, they Lordship deployed as Panchayat executive officer to the different Gram Panchayat Lordship. And for the first time, Lordship, 21, they have come up with the rules, Lordship, for appointment of this Panchayat executive officer by of these rules, Lordship. Here, Lordship, there
By not rules, this is the act,
Lordship.
by amendment of the act.
No, in fact, Lordship, kindly see the language, Lordship. They have come up these rules. In fact, Lordship, very
No, you are referring section 122 of the act or,
act, Lordship.
so it's an act, not rules.
Not rules, Lordship.
Correct.
Act speaks of a particular post under the statute. Lordship.
Correct. It says that in every Gram Sasan, there will be a Panchayat executive officer to be appointed by the state government.
State government.
By the collector, sorry.
Collector.
Collector.
By the collector.
So, what is the difficulty?
No, sorry, Lordship. What happened, Lordship? Though this provision is available, the post is Panchayat executive officer. It was never, Lordship, appointed in accordance with the rules, statute, Lordship. What they did, Lordship, they, Lordship, borrowed the post of the VLWs and PLWs of the district and they deployed to different Gram Panchayats.
So, you are not really against the amendment having brought. Why is you are not challenging? You are challenging, you are agree by the manner in which the appointment is made. True.
And they're going to make
But you have challenged the virus, that's why I am asking.
Lordship.
You have brought to notice acceptance. The acceptance is this method of recruitment and conditions of service rules 2021. You are agreed by this 21 rules.
Rules.
Why?
Lordship, there are two grounds, Lordship. There are number of writ application, Lordship. Some of by the Gram Rozgar sectors, those who are working under
by virtue of these rules, is it contrary to this 122, section 122?
I am saying that it is contrary to Article 40 and 243G, Lordship. Both, Lordship, because it is contrary to the.
Show us the provision is auto. The Constitution. Here you're talking about these are the municipalities. Where is the Panchayat?
Lordship, Article 40 and Article 243G, Lordship.
Sir, 240.
That is Panchayat, Lordship. 43 G, 43G, Lordship. Powers and authority and responsibility of the Panchayat, Lordship.
Yes.
Subject to the provisions of the Constitution, the legislature of the state may by law invoke the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government, Lordship.
Sir, the Panchayat, what is the difference? The difference is that still the power of the Panchayat is still there.
But Lordship,
The decision of the Gram Panchayat will be paramount. Only thing is that who has to be entrusted to take care of these funds, to take care of the documents, to take care of these. This has been given to a
this executive officer.
But has think lordship, it lordship interferes lordship, it violates the autonomy of the.
No, not interference.
That's
The act itself says that they have to act under the surveillance or a supervision of the panchayat. 122 subsection 3.
But here lordship, let me, some facts are something different lordship. Let me
It
place
says that subject to the provision of subsection 1, Panchayat executive was function under the control and supervision of the Gram Panchayat.
Lordship.
So he is under the Gram Panchayat.
But lordship, if somebody appoints us collectively appoint my staff. Lordship,
What staff? Who are you?
Lordship, I am the lordship Gram Panchayat, I am the Sarpanch lordship. Lordship, so my staff lordship cannot.
I understand.
Lordship, Lordship, if the collector will monitor, lordship, handle my staff.
It is a fight for a thing which Mr. Kutia does not have.
Sets up writ application before lordship. So once the Gram Panchayat has come and others not the Gram Rozgar Sevaks, those who have been appointed under the Gram Panchayat, lordship by way of special that is NGNRS Act lordship. And by virtue of government circular lordship, they have been absorbed at the ratio of 70-30 from the day one lordship. Now for the first time lordship, the state government has come up with this notification, this rules lordship, by giving appointment and creating a post after more than 20 lordship, more than 30 years of the lordship, 7th amendment.
Consider this.
Yes,
You are not considering the amendment having brought in section 182 of the Panchayat. You are not.
That is not there, lordship.
You are not challenging.
Please
consider what is in my mind. Unless I express, you will not be able to assist me on that. You are not challenging the amendment having brought in section 122.
Yes.
You are challenging the particular rules which was enacted for the purpose of adopting a procedure relating to the service conditions or the services of the or the method of recruitment or the condition of service of those Panchayat executive officers. Now there are two things. First thing is, if the Panchayat executive officers are to be appointed by the state government,
yes,
then they have an authority to decide how they will initiate a recruitment process and what would be the condition of service of those officers.
Yes.
Secondly, if the state government is empowered to appoint, then the state government is also empowered under the constitution to enact the condition of service, the recruitment process. Both. The Panchayat does not have any role into this because this officer is to be appointed by the state government.
Yes.
How the Panchayat will say that you cannot adopt this method, you cannot put conditions of service? How can you say?
That's why let's say two sets of writ application before lordship. One is
you are not challenging 122.
No. So, in this,
both.
Lordship, it is not for us not required lordship to challenge 122. Reason being lordship, let's say two sets of writ application. One lordship has a set of writ application by the existing employees, those who are working under the Gram Panchayat, and they are guided under the rules of the state government, and they have a scope lordship.
Here, this rule of 2021
lordship
is the rule relating to the Orissa village level. is relating to Orissa Panchayat Executive Officer Service. Method of recruitment and condition of service.
It is a post under the Gram Panchayat Act, and we are functioning, Lordship. We are still there, Lordship. So both the Lordship, employer and employee.
Probably you could have unable to express very clearly.
Lordship,
If you have no grievance, now I am coming very straight.
Lordship.
If you have no grievance against the appointment of the Panchayat Executive Officer,
Lordship,
because you are not challenging section 122, then can you raise a grievance of the method or a mechanism or the procedure to be adopted by the state government in relation to the recruitment of that Panchayat Executive Officer or their condition of service? Can you raise? It is between the state and the officer who is to be appointed by the state. How can you come?
Yeah, that's why, Lordship, I am saying that two sets of writ applications. Lordship, because Lordship, if the Sarpanch is challenging, then Lordship, that can.
So he is above the law.
No,
because he is.
No, Lordship. I'm coming later. So far the Sarpanch is concerned, I will come later, Lordship. So my first contention, Lordship.
Let us go. The Panchayat, Gram Panchayat has come. Let us proceed.
Lordship,
how can you?
My humble submission, let the employees first, Lordship. Because the past cases are, Lordship.
How you are affected, sir? You are still your employment is not going to be taken off.
Yes, Lordship. I'll demonstrate, Lordship.
Sir, what are you talking about?
Lordship, I'll demonstrate, Lordship.
What?
Lordship, kindly please.
Please tell me. What?
I can demonstrate, Lordship. That was
Sir, you are not a Panchayat Executive Officer.
Lordship, I was performing the exact duty, Lordship.
So that does not mean that you not challenge.
No, the government has come up with the rules, Lordship, to accommodate me. Lordship, the government
be accommodated whatever in the capacity, but not as a capacity
that is still there, Lordship. That is still there. I am, Lordship, under the Lordship consideration zone. In between, Lordship, they have come up these rules. Lordship, when Lordship, please, Lordship, kindly bear with me, Lordship. Lordship, kindly come to please Annexure 1, Lordship. Lordship, kindly come to Annexure 1. Or Lordship, tomorrow at 5:30 only, Lordship. Tomorrow
no, I can continue up to 5. Don't worry.
Lordship, the time I don't want to take risk. Lordship. Let talk some other day, Lordship.
Consider this.
I'll answer, Lordship.
Me.
No, I'll answer, Lordship. I'll try to convince.
In 2008 rules, village level workers were being considered.
Lordship.
Those rules are superseded by these rules. In these rules, separate set of eligibility criteria has been fixed for the purpose of recruitment.
Lordship.
Right.
By taking our right. By
What
taking
right?
our Lordship. Because Lordship, we are supposed to, Lordship, to contact that post.
Unless village level worker who is affected, he has not come forward.
No, Lordship, village level workers are subsequent to 13, it came to GRS, Lordship, Gram Roda Sevaks. We have been promoted because that entire appointment existed in 2008, Lordship. All have been observed as Panchayat Executive Officer. Then, Lordship, our role came, Lordship, we appointed a Gram Roda Sevak as GRS, Lordship. Then, Lordship, government came up with rules.
You are taking a risk.
At 4:30, I will not receive. Let it come from mother first case, Lordship, I will not convince, Lordship.
That's difficult, sir.
I will try to convince you, Lordship. Because, Lordship,
Your services are not affected by these rules.
Lordship, because Lordship was able to, because it was had
Only
a
if you are eligible, you can compete. You can compete and offer your candidature as a Panchayat Executive
Yes, when the subordinate staff elections, we will appeal.
They didn't Lordship fix it then interim to continue.
You have to.
Item number 30 may be taken up to.
Interim order in this.
Item
There because the 7, Lordship, the existing rule, Lordship, 70-30 will.
Interim order was passed.
Yes. Lordship, in order there. Interim order there, Lordship.
When?
My Lord Justice Talapatra and Justice no. Their Lordship's first interim order
Directly in that 30% reservation maintained. Only because we are getting 30% also. That is their entry model there. Because they have prepared a gradation list. All of a sudden they supersede the gradation.
Do not want to make an observation.
Item number 30 will be taken up tomorrow.
Day after tomorrow?
Entry model.
Day after tomorrow?
Yes.
Yes.
29. And intend to continue also.
You are more interested in the interim order than the
Lakshmana, both. We are both.
Yes.
I don't think.
Let the other matters continue. I will start from there.
I don't think the interim model will continue.
Tomorrow, let's start with the session.
In our case, interim.
After this, your matter is item number?
Same metallurgy, 26. Our metallurgy.
So tomorrow I will start with the roster from 27.
That's right.
Obliged.
Say on this, it's not repeating, just say that from tomorrow, today, the matter from item number 27 of today's list can be taken up first.
Let our matter be taken up tomorrow so that 26th. Let the compiler not insist
With one assurance or the undertaking that you will not take more than 5 minutes.
5 minutes, sir. Shall take at least 15 minutes, sir.
If you
I am comfortable.
give an undertaking not beyond 15 minutes, we are ready.
15 minutes, sir. I can control. My part I can control. 15 minutes, sir. Plus.
Good. Not 26.
Good.